As you know, in the formation of this country, when you had states before there was any central or federal government, they had their own charters and they did their own business. And they got together and they said, you know, there are some onerous things that we have to deal with. It would be good if we had a federal government that could take care of some things. So they got together and they said, let's form a federal government. But they wanted to make sure in the formation of this federal government that there was no mistake that this federal government could only have a very limited delegated power that they gave it. And they wrote a constitution, and a lot of people think the Constitution was written to establish and bestow rights, but it was not. Because government cannot bestow rights. God bestows rights. Government can either protect them and defend them or take them away. So they established a constitution, I think, for the primary reason to create big chains to chain down the federal government so that they only operated in the venue with the delegated powers that they were given. It turns out to be very interesting because when they also wrote this Constitution, they said we're going to divide it up into 3 branches, a horizontal system of separation of powers. They said we'll have a presidential side or a president that's going to be with the executive branch. And then we'll have a legislative branch that makes law that deals with just the delegated power things that we gave you. Now, by the way, what were those things? Well, there was about 18 of them. That's all. Things like immigration, things like coining money, things like creating an army and a navy, things like interstate commerce and trade, those kinds of things. There were about 18 of them. And the founders, when they created this government, they wanted to make sure that the government understood that they were creating, that you have this small little garden to hoe in. It's got these 18 things. All this big garden belongs to the states. So you hoe in your little garden and stay out of our garden. That was their thinking. And in the amendments that they said, they weren't to delegate liberty or freedom because those things are not delegated by government. They're given by God. But when they set that up, it was like they said, to make sure you understand that when it comes to these fundamental things, you don't mess around in them. For example, the First Amendment to the Constitution says Congress shall make no law, none, zero, no law. When it comes to a man speaking his mind, when it comes to religion and the establishment of it and the free exercise of it, you stay out of that. The Second Amendment, the same thing. You stay out of that. The Ninth Amendment, all the rights that we enumerated came from original rights called common law before the Constitution was ever written. And the Ninth Amendment says the people retain all those as well. And of course, the 10th Amendment says what I said about the gardens. You have a small garden, stay in it. We will never give up the sovereignty of states. That was their thinking. So they created these 3 branches, and they wanted to make sure that if a federal judge said something, it was not law. If the President of the United States gave an executive order, that should only affect the executive branch of government, by the way. It was not law. They also made a vertical separation of powers. The sovereignty of the states was superior. The federal government was inferior. That was the plan. Well, the topic must have come up. What do you do when a judge tries to make law? What do you do if the president tries to make law? What do you do if Congress passes a law that is not constitutional? Well, they must have discussed it because they talked about it. Let me tell you what they said. In Marbury versus Madison, they said, this was in 1803, by the way, they said, a law repugnant to the Constitution is void. In an ex parte with Siebold in 1879, this is what they said. An unconstitutional law is void and is as no law. An offense created by it is not crime. A conviction under it is not merely erroneous, but is illegal and void and cannot be used as a legal cause of imprisonment. In Norton versus Shelby County, they said in 1886, an unconstitutional act is not law. It confers no rights, it imposes no duties, it affords no protection, it creates no office, it is in legal contemplation as inoperative as though it had never been passed. In Miranda versus Arizona in 1966, this is what they said. Where rights secured by the Constitution are involved, there can be no rule making or legislation which would abrogate them. When Thomas Jefferson was talking about the Kentucky Resolution of 1798, this is what he said. Whensoever the federal government assumes undelegated power, its acts are unauthoritative, void, and of no force. He added, where powers are assumed which have not been delegated, a nullification of the act is the remedy. That every state, that's our state, that every state has a natural right and duty in cases not within the authority of the Constitution to nullify of their own authority all assumptions of powers by others within their own state boundaries. That's what they said. Well, that played real good for about the first 100 years, and then slowly the federal government began to run tentacles out of their garden into ours. So I want you to understand, this bill does not force the legislature to nullify anything. This bill simply says, if you're going to, this is how you do it. So this bill says there are 5 ways that you can deal with the nullification issue. By the way, this bill says, what is a nullification? It's a process whereby this state makes an official declaration that a specific federal action has exceeded the prescribed authority under the United States Constitution. That action as being ultra vires will not be recognized as valid within the bounds of this state. That said action as being ultra vires, which by that way, that term means it's beyond one's power of authority, is null and void in this state. Now, this bill describes 5 ways that can happen. The first one is if the federal government or the president or a court makes an edict that affects the executive branch of this state, the governor has a right to nullify that, and that affects the executive branch. If a state judge is dealing with a case and involved in that case is a piece coming out of the federal government that judge believes is blatantly unconstitutional, that judge could nullify that piece. The third way you can do it is if a legislator runs a bill of nullification. But there's a couple of things that hang on this. If you run a bill of nullification, you can take it to a committee process and you can haggle over it and argue over it and wrestle on whether it's constitutional or not constitutional and what we ought to do about it or not do about it, but you can't kill it. It has to go to the House floor for a vote, and it has to go to the Senate floor for a vote. There's a fourth way, and that's based on the very first words of the Tennessee Constitution that says all power is inherent in the people. You do understand that all power is not inherent in the legislature. The people loaned you and me part of that power while we're in session. All power is inherent in the people. So the fourth way you could nullify or get a ball rolling to do that is if 10 or a combination of 10 municipal governments and county governments send a letter of petition to the Speaker of the House asking for a particular action to be nullified. And when the Speaker verifies that these are 10 valid city or county governments, he submits a bill with our process that goes through the same process as I just told you as a legislator would do. It has to abide by the same rules. The fifth way, by the way, there is another way, but it's not in this bill. But in criminal court, criminal judges don't tell juries anymore, but juries have a constitutional right to nullify law. But that's not in this bill. The fifth way is if 2,000 signatures of registered voters are submitted to the Speaker of a House in a petition, and you cannot have less than 25 in any county, and they have to be bundled up by county, but 2,000 signatures of registered voters in the state of Tennessee send a petition of nullification to the Speaker of the House, then he verifies those signatures, and then he submits a bill, and it goes through the same process as before. Now, again, this bill doesn't force the legislature to nullify anything. It just says if you're going to do it, this is the way you do it. Now, I know the governor has flagged this bill, and you've gotten visits from really good people, really nice people. They're good folks. And they're worried because they do a good job and they do good work, and they're worried that we'll lose federal money if we didn't talk about this. I got to remind you, you and I stood up on that House floor over there a few weeks ago, and we raised up our hand and we swore to 7 million people in this state. We swore not that we would rake in all the federal money we could get. We swore that we would always defend the unalienable rights of Tennessee people by defending and upholding the Constitution of the United States and the Constitution of the state of Tennessee. We should not be for sale. I want to tell you that deep in my soul, I have a conviction that is deep-seated. I believe that if state legislatures in this country do not stand up and hold the federal government to obey the Constitution of the United States, we could very easily lose this republic. That's what this bill does. There you have it.
Thank you on many levels for that history lesson. Thank you very much.